Good morning, everyone, and welcome to the mandatory regulatory compliance series organized by the UK-Ghana Chamber of Commerce. Today, we are going to look at navigating Ghana's labor laws and regulation. And this is a series that has been ongoing since last year, and we are happy to today look at the labor law issues. And so, I will introduce myself. And my name is Theophilus Tavia. I'm a lawyer. I'm a law lecturer at UPSA Law School. Beside that, I'm also a managing partner for WTS Ghana, a legal firm based in Accra. And I'm a director at the UK Chamber of Commerce, where I'm responsible for legal and regulatory matters at the Chamber. So I'm happy to welcome you for today's session. And so ground rules, if you have any questions, you would have to press the button, the hand raising button. And also, if you want to, you're free to also put your questions in the Q&A, the chat box. So to help me deal with today's matter is Stephen Osei Kisi. Stephen is an industrial relations and ADR practitioner with a decade and counting experience in National Labour Law Commission. He provides assistance to parties in an employment law relationship to solve their differences, and he offers support for employment relations and dispute resolution. He's currently the head of Greater Accra Secretariat of the National Labour Commission. He teaches labor relations and dispute settlement under the Labour Act and has shared classroom experience with students from the University of Professional Studies Law School, where I teach, and the Ghana Telecom University, and also offer labor consultancy. He's a lawyer and a member of the Ghana Bar. So Stephen Osei, we're happy to have you here. And so I will give you about 10 minutes to do a presentation. Then we'll do the questions from there. So you have your audience, Stephen.
All right. Good morning, Senior, and welcome to everyone who is joining us online. I'm sure that it's for a very particular reason why the UK GCC has decided that you'll put this series together so that over time, the general public can get to appreciate the basic nuances of our labor law. And so I'd want to commend the UK GCC for putting this together. Immediately, I'll just do, I'm hoping to do a 10-minute overview of what our Labor Act is, what has gone into it, the various sections, and the various innovations that have come up with following the passage of this particular act. And so you'd find that sometime in July of 2003, the Parliament of the Republic of Ghana passed the Labour Act, and in October of the same year, it received presidential assent, was gazetted, and it came into force beginning 31st of March 2004. Now, the whole idea of putting together the labor law at the time was just to make sure that there's a proper consolidation of the various laws that were governing labor at the time. And so it's easy to say that it's more of a piece of legislation that has seen the coming together of all of the social partners to embrace the kind of change that we needed to see within our labor front. There's also provision for gender sensitivity, where you find basic words like he or she or him or her. The language that has been used in putting the law together is one that with just a little education, you should be able to understand what it means and how you can implement them. And again, it's just to make sure that the labor law as it is would have the spirit and the letter of the 1992 Constitution, which is the ultimate constitution the ultimate law in Ghana, and also to make sure that it is in line with the various ILO conventions to which Ghana has ratified. And so you would find that in terms of its application, it's to all workers and all employers. So you see that there is no distinction as to whether it is a house help or it is a receptionist or a bartender. It says all workers and all employers. The only exception the law sets in is the exception that relates to those in the armed forces, the police service, the prison service. And because those are covered by the Security and Intelligence Agencies Act of 2020, Act 1030, you find that those persons do not fall under the operation of the labor law. Now, there are a number of aims that the labor law has put across. So you find that I've put together 7 aims that are seen or that guides the whole idea of how the labor law is to work. So the first is that it's supposed to put together all of the existing legislation on labor into conformity with the Constitution, as we already mentioned. And so you would find that in the Constitution under Article 21(1)(e), it says that all persons shall have the right to freedom of association, which shall include the freedom to form and join trade unions and other associations, either national or international, for the protection of a person's rights. So these rights are guaranteed under our Constitution, and the labor law seeks to conform to same. Now, again, there is also the provision that is made to make sure that the existing labor laws are more user-friendly in terms of language and content as well. Again, there's provision to decriminalize some industrial and labor issues. So you'd find that under Section 104 of the Act, some provision is made available to cater for these. Again, it is also said the aim is to provide a more responsive and flexible legal regime to help in the quick resolution of labor issues and disputes as and when they arise. And so you'd find that there's more, the language, as we have already said, and how it is supposed to be implemented and practiced is geared towards a more friendly nature. Again, the whole idea is also to bring the Act within good practices which have been developed over the years beyond just the labor law as we have it. And so it has some provision for the creation of the National Tripartite Committee under Section 112 to 115, where in Ghana, when we hear of the Tripartite Committee, the first thing that comes to everybody's mind is minimum wage. So yes, so that committee sits with government to negotiate the daily minimum wage, which currently is around 14 cedis and 88 pesos. There's also provision in the law for casual work under Section 73 to 78, and also sets out some good guidelines for unionization. And lastly, it's also to rationalize government's role as a policymaker and also as an employer, because we all know that at present, government is the largest employer as you would have. And so, yes, it's also to make sure that its role as policymaker and employer is also duly catered for. So at first glance, the Labor Act has 20 parts. It has 179 sections with 4 schedules. It has a provision for interpretation and definition of the various words that have been used. And it all put together comes to 69 pages. Now, a number of innovations, as I mentioned in my introductory remarks, have been made following the passage of the labor law. So, number 1, it makes provision for the registration and licensing of private employment agencies, so that if you want to carry yourself as a private employment agency, there are certain obligations that you need to satisfy before you can be licensed and registered as such. There's also provision for the protection of employment under sections 8 to 19, where you'd have rights and duties of both the employer and the worker, and provision is made for a certain period of time where you must issue the contract of employment. Another innovation is that there's room for the employment of women, young persons, and persons with disability. Incentives are made for entities that would employ persons who have disabilities. There's also the innovation of maternity leave arrangements, where you have a minimum of 12 weeks for a nursing mother, and it's extended to 14 weeks if the said nursing mother gives birth to twins. There's also provision made for redundancy, I think, under Section 65. And it goes on to make provision innovations for unionization and certification. Another key innovation is the establishment of the National Labour Commission, for which I'm a staff. And then there's also provision to cater just in the event of strikes or lockouts. And also there are provisions that are made to cater for essential services under Section 162. And also if you look at the LI, which accompanies the labor law itself under Regulation 20 of LI 1833, you have a number of entities that have been listed as essential service providers in Ghana. It also doesn't mean that in the private sector you can't have an essential work. You can, but these are the provisions that the LI together with the labor law has made available to everyone. Now, in terms of challenges, I think that over the years, what we have seen is one key challenge is the potential multiplicity of workplace unions, and forgive for the repeated words. So you'd find that in a number of, in the particular entity, you can have a multiplicity of unions being present, and its management at some point gets to be challenging. Again, there's also the challenge of the class of workers which should be unionized, because under Section 79 to A to F, you would find that certain persons like policy makers, decision makers, agents of a shareholder, just to mention a few, are persons who ideally cannot be a part of a union or form a union. And so in handling these things, the whole idea is that it must be dealt with, in a very nice way, so that everybody can be satisfied to some extent. Again, there's also the challenge that has to do with operationalizing the various institutions under the labor law. So you'd find that ideally, following the passage of the law, we should have offices of the National Labour Commission dotted across literally every region in Ghana. But as we speak today, we have a total of 4 regional offices. So there's the head office in Accra, there's the regional office here in Tema, then there's the Ashanti regional office located at Ahojo, and then you'd find the secondary Takrady office located at the Anaji Estate. So ideally, I know as of now, there are plans to go to make an office arrangement for the northern part of the country. So the commission is looking at going into either Tamale or the Bono region, depending on provisions made available in terms of finance. Then there's also the operationalization of the National Tripartite Committee and also private employment centers. Another challenge is the need for stakeholders to accept and embrace the number of changes that the passage of the labor law has brought into labor administration in Ghana, and also to have a proper determination of essential services, both at the national and the enterprise levels. There's also the challenge of a need to sensitize all stakeholders, and I think that this forum, as we have now, is one that I think that ideally tries to satisfy this need of sensitizing every stakeholder. And then also, there's also the challenge of the need to offer protection for workers in the informal sector as well, because you would find a number of complaints coming to the commission from the informal sector, and you get to appreciate that the knowledge and operationalization of the Labor Act is literally non-existent. And also there's the issue of payment of remuneration during a strike or a lockout. Then there's also the challenge of matching remuneration with productivity. Now, just to conclude, the whole idea of the current labor law is to introduce a certain era of ensuring a harmonious relationship between both labor and capital, or both employers and their workers. And the whole idea is to ensure that this coming together is for the common good of all. Now, the current labor law has been in practice for almost 20 years. Now, at present, there is some review going on to ensure that when the review is complete, what would now come out would more or less, if for nothing at all, get to satisfy or push the law to meet up with current labor trends as we have it. So this is just by a quick overview of how our labor laws has been set up. And at this point, I would defer to my senior to lead us in going on with our conversation.
All right, Stephen, thank you very much for such an insightful presentation. I would go on to ask the question. You talked about the fact that the Labor Act applies to all workers and it makes an exclusion for armed forces, police service, and prisons. So, what would you say is the meaning of a worker? Because in other jurisdiction, what considered a worker is quite different. So, from the Ghanaian point of view, who is a worker?
Well, from the Ghanaian point of view, a worker is any person who has submitted his knowledge, his skill, his strength to an employer with the idea that at the end of every determined period, he is awarded in terms of either a wage or a salary for that skill or and knowledge and expertise that they bring to bear on the employer's organization. So that literally will qualify somebody to be a worker.
So would you say that within the architect of the Ghanaian labor system, a worker covers a permanent staff, a casual staff, temporary staff? Is that the case?
Yes. So in the strict sense of labor law, a worker would cover these status that you have put across. So it will cover a permanent staff, a contract staff, temporary staff, and a casual staff as well.
Okay. We have a number of SMEs on the call, and so what would we advise for? I mean, a business leader who's running a business and making a recruitment. What are the checklists that you think that they should consider when they are employing a worker?
Okay. So beyond just the person's qualification, I think that's the one key thing that employers can put in place is have a pretty precise job description. You would find that in a number of complaints that come to the commission, the issue of what the person is supposed to do also becomes a challenge as to how you are even able to resolve the dispute, because the person comes in and there's no clear definition of what you are expected to do. So in an instance, somebody is employed as a front desk person. This same front desk person is expected to do the office cleaning, is expected to do, sometimes they even say that go to the MD's home and go and clean. So you ask yourself that in that circumstance where there's the absence of a clear definition of what the person is expected to do, in the event of a dispute, you realize that the settlement becomes difficult, not just on the worker, but also on the employer as well, because then you would have to try to define the scope within which the person has been employed. So I would say that beyond just the person's academic qualifications, some careful thought should be given to what goes into the job description, so that, and then also we should have clear reporting lines. It makes it easy for us to determine who we can lay blame squarely on if we have to, or who we should go for in terms of seeking further instructions in carrying out our work.
Thank you, Stephen. I know Section 12 talks about providing a written statement of the terms if it's within 6 months, and if it is, I think 13 also talks about if it's more than 12 months, then it should be support. The 13 rather talks about written statement of contract, and 12 talks about an employment contract. But I don't see any punitive. I don't see any. I mean, the law does not prescribe if an employer does not issue an employment contract or a written statement as required by the law, they're not punitive, and it gives employers a leeway to mess up with employers. I don't know what's your
Okay.
thoughts about it.
Well, I that's one key area that has come up in terms of the operation of our current labor law. Now, the whole idea of not having punitive measures in our labor law is because of the nature of how the law has been put together. It's more of a social legislation. And so you would find that the whole idea of its operations is to ensure that all of the stakeholders in this situation, organized labor, employers association, and government, all of these stakeholders have a key take on how the law should work. So the whole design is geared towards making things flexible as much as possible, so that you won't find the strict sense of a punitive measure spelled out clearly in the law for failing to issue a contract of employment or an appointment letter. But the danger for an employer who decides that, well, because there is no punishment for not giving an appointment letter, I will not issue the appointment letter. The danger for that employer is that in the event of a dispute, then you would have very little defenses to put up for whatever action you may have undertaken, because then it means that in that instance, we're going to fall squarely on the provisions within the labor law. Now, if you breach 12 and 13, as you've tried to explain, then you ask yourself, what other comforts would the law allow you when you have failed to, comply with the basic requirement of issuing an appointment letter? And so I would advise, and I hope that everybody takes it in good faith, that once you know that whatever employment relationship you are seeking to build will run beyond, just like the 12 has made have made provision for, it will run beyond 12 months. Secure it with an appointment letter. It's to serve your interest as an employer, and also to serve the interest of the person you are bringing in as an employee, so that if there are issues, we know what to do and what not to do. And so, yes, I am hoping that the review will probably have a look at the implication of sections 12 and 13, and if some further provision can be made available to cater for persons who decide to make these breaches, then I'm sure that then it would fall in line with having a holistic measure of catering for the labor relationship.
So I get a sense that it's important that you secure an employment relationship with a written contract, and that's a very key to avoid dispute. Could you run us through what should be provided in a written contract for an
Okay.
employment for the purposes of our listeners on the call? I mean, what basic provisions should be set out in the employment contract, or when they choose to go by the written statement of terms, what
Okay.
should be in there so that at least the listeners are more abreast of that?
Okay. So you would find that Schedule 1 of the labor law, as we have now, makes provision for the particulars of a contract of employment, or what the law considers to be, if for nothing at all, these things should be a part of somebody's appointment letter. So you would find that under Schedule 1 of the labor law, it says some of the things that should be there is that you should have the name of the employer, you should have the name of the employee or the worker, you should have the date of appointment, you should have the job title or the job grade within which the person is being employed into. You should also have in terms of what would amount to the salary, the periods within which it is supposed to be paid, and how it is supposed to be paid. Again, you should have elements like the number of hours a person is supposed to work. You should also have elements of period of rest and period of holidays as well, and its full details. You should also have conditions that relate to incapacity to work due to a number of reasons, such as ailment or injury or sickness, and the details, if any, if somebody is cannot work because of an illness or an injury, how that relationship is going to be treated. should also be a part of the contract of employment or the appointment letter. Then there's also the details of Social Security and the pension scheme as well. If you have a pension scheme, then you should have another key element, the amount of notice to terminate should be there. So on the employer side, what would qualify as a reasonable notice period, and then on the employee side as well. So you would find that in the law says that if the relationship goes beyond 3 years, the notice period is a minimum of 1 month. If it is under 3 years, the notice period is a minimum of 2 weeks. Now, if the parties by themselves decide to contract beyond the 2 weeks, if it's under 3 years, and 1 month if it's beyond 3 years, then that is what will take precedence. And then you should also have elements of rules that will cater for discipline, and also the process for dealing with any grievance or dispute should it arise, and then issues that make provision for overtime payment, if any. And then you have your signature, it's dated. So ideally, these are the elements that an ideal contract of employment should have.
All right, thanks, Steve. So what about if, for example, the contract left provisions like possibly maternity leave, rest break, holiday? Would you say that it is implied into the contract by reason of statute? Because it is not everything that you would normally find in an employment contract. Would that be a good practice, or you think that everything should be bogged down in an employment contract, or should be set out in the staff handbook?
Well, usually because of how employment contracts are put together, you would find that just so that they don't come across as being voluminous or being too bulky, you would find that it's written, give or take, a 2-page, and then every other element that will cater for the relationship is found in, like you mentioned, either the employer's handbook or the employment handbook, or a condition of service, or a collective agreement that has already been negotiated on. So in the event where a contract of employment is silent on issues like leave or maternity leave or other instances, the beautiful thing about our labor law is that there are minimum provisions that are made available. So if an employer says, well, I gave you a contract, but I didn't mention that you are entitled to maternity leave. Maternity leave is an operation of law. So once a woman conceives and has a baby, the idea is that automatically that right of maternity leave is gained by the said nursing mother. And so even if the contract of employment is silent, because there is provision in law to cater for it, then an employer cannot say you cannot grant the maternity leave. And I'd also want us to note this, that maternity leave comes with pay as well. A number of times you find people call us and say, oh, I have a staff who is going on maternity leave. Should I continue to pay the staff? Yes, the person is only going on maternity leave simply because the person has given birth to a child. And so the person should not lose out on their salary simply because they are going to be away from work for a minimum period of 12 weeks. So yes, where there are no express conditions within the contract of employment, then we'll defer to the provisions within the Labor Act.
That's a very good point. So what it means is that the labor law would be implied into the employment contract if it's silence on it, such as the rest break and all that.
Yes.
So my question also borders on leave pay. No, the number of days for leave. We have annual leave, but you will not find in the statute, the labor law, talking about how many days a person is entitled to as leave pay. Leave at the sick leave. Do you have any convention? Because I've heard someone telling me that, well, you're entitled to 15 sick leave. Is there any convention? Is there any regulation or any directive from your end that suggests that an employee has a number of days as leave days? Because in an organization where a person becomes sick frequently, every day taking leave. I mean, is there any protection for the employer?
Okay. So leave, ideally, per our law, an employee has a minimum period of 15 working days as leave within a given year or within the calendar year, so that for every 12-month period that you stay in employment, the law is saying that you have a minimum of 15 working days. It means that the weekends are not counted as part. So the provision there is it's 15 working days. Now, that's to cater for your annual leave. Now, till present, there is no expressed directive, let me just put it that way, from the commission that says that for every given period within an annual year, an employee also has, beyond just your annual leave, there's also some extra provision for sick leave, because nobody at any time can preempt when you can fall sick, or the consequence of the sickness on you either immediately returning to work or staying away from work for a while. I think that the only persons in labor administration who are able to tell how long somebody should stay away from work as a result of an illness or an injury is a certified medical practitioner. So they are able to do a proper assessment, and then they say maybe for this particular ailment or for this particular injury, stay away from work for 2 weeks or for 1 month or for 2 months or for 3 months. Now, it is for all employers to be able to come up with policies that will regulate issues bordering on sick leave, so that if I fall sick and the doctor says I need 2 weeks away from work, and I come back after 2 weeks, I fall sick again. Now, it's up to the employer to have a certain policy that would either consider a continuous relationship or looking at some other avenue that would bring the relationship to an end. Because if you look at that section 15, one of the grounds for separating the relationship would be on ill health. So if a person is not, or sickness, if a person's sickness is such that it makes it difficult for the employment relationship to be kept, then there are provisions made available for both the employer and the employee to explore to be able to bring the relationship to an end. But in terms of statute, there is no limited number of days that a person would generally require within a given year to cater for a person's sick leave. So it's usually more of an employment, it's more of an employer policy or a negotiated agreement between an employer and the union if the environment is unionized.
Okay, so thank you very much. Is it possible for an employer to contract out of statute? So let's say maternity leave. Can the employer say, I'm going to pay you half of your salary, and then maybe give you four months, and that will mean that the employee and employer are contracting out of statute? Would that be permissible? What would be the legal implication for that?
Well, Senior, once the parties contract out of statute, then it means, ideally, with my little understanding, what that would mean is that whatever they have agreed on does not have any proper legal backing, and so it's an agreement that you can say is illegal or is null and void. Because, like you mentioned, maternity leave, the law says you have a minimum 12 weeks, paid 12 weeks away from work. So an employer and an employee cannot sit down and say, okay, in the 12 weeks, I want to opt to give you 16 weeks, but I'll give you salary for 8 of those 16 weeks. And then the remaining 8 weeks, I will not give you salary. No. At all material times, the minimum provision that the law has made available must be complied with. If the parties want to build on the minimum to enhance it, the law will not have any issue with it. But if whatever change is made is to the detriment of the employee, then the law will raise red flags, and the employer would have questions to answer.
That's quite an interesting point. So you're saying that they cannot contract out. The only thing they can do is to rather build on the system minimum, statutory minimum, So if they want to give the person 6 months maternity leave, there's no problem with it. All right. So let's go on the issue about termination, because I know a number of times people drag employers to your end on dispute resolution matters. From your end or from your experience, what are the common things that normally come up at your end in terms of termination?
Well, at most times, it's simply because the parties have failed to go by the terms within their contract of employment. And so you would find one party say that, mostly the employee, say that my employment has been unfairly terminated. Now, coming to the commission to say your employment has been unfairly terminated does not automatically mean that that really is the case. There could be situations, and there's been a number of instances where the terminations have been in order. And so in as much as the complaint was geared towards an unfair termination, there's been a number of rulings from the commission that says that no, this termination was fair, and therefore your complaint itself doesn't have proper grounds. So I would say that per our statistics, now, if you pick every 10 cases, you should have about 6 out of the 10 bordering on issues of unfair termination. So the commission is then forced to ask itself a number of questions as to how people have come to appreciate the provisions that are in the labor law on how you're to protect the employment, number one, how you are supposed to exact discipline at work, number two, and in the course of exacting discipline, how you should go about it, number three. Now, these instances would then give rise to whether or not a person's termination would amount to a fair one or an unfair termination. And so depending on where you find yourself or the instance, then we'll look at those provisions under the labor law, and then we'll treat the situation. Because you would find that section 15 will tell you that have grounds, and then 17 will tell you that there should be notice. Then when you move from 15 and 17, it will come to 62, 63, 64, which has provisions for what will constitute a fair termination, what will constitute an unfair termination, and if the commission should find a termination to be unfair, the avenues to resolve. So you either get a reinstatement, you either get a re-engagement, or you are asked to pay compensation for the unfair act that has been meted to the other party.
Thanks, Steve. And so you would observe from most employment contracts that you can sever the relationship by giving a notice. And there are no requirement by the court to say that you have to give reason for the termination. Those under collective bargaining agreement are expected to be given notice for termination. Isn't that unfair? Because everyone is equality before the law. So why would people under collective bargaining agreement be entitled to be given a notice, whereas in an ordinary course of employment, you are not supposed to give reasons for terminating? I don't know whether you get my question.
I do, and that's a personal concern I have, that an employer can wake up in the morning and say, I don't like that. I don't like the fact that today you are in a blue tie and a white shirt, and so let's call the relationship over and let's move on. Or the employer doesn't even tell you even why the relationship is coming to an end at all. It is for that particular reason that you would find that our labor law is set out in a way that before you even contemplate ending the relationship, section 15 will tell you that before you go ahead to give notice, ask yourself if you have a ground for letting the relationship go. Now, the reason why I'm saying this is this. Should that be the case and the employee walks away, there are no issues about it. But should the employee come to the Labor Commission to say, I am suspicious that my employment has been terminated unfairly, and the commission looks into the matter and there are no express grounds for the termination, and the employer has not been able to espouse a fair reason for going ahead to terminate, then there would be questions, and in the likely situation, such an employer would be made to pay compensation to the employee, or we may order a reinstatement or re-engagement if the commission thinks that the relationship is one that can still persist. So yes, like you explained earlier, where there are already agreed provisions on how we are to treat terminations, those terminations cannot be breached. And I believe that there are a number of instances from the commission and even the courts that support this assertion. And then there's the other side where the employment contract itself is silent on grounds for termination, or whether or not the employer should give you a reason to terminate. That is where a lot of the issues come from, because if you look at how the labor law works, then you would find that at all material times, if an employer is not able to provide a ground or some fair reason as to why the termination, the employment relationship must come to an end, then, like I already mentioned, there are certain questions to answer, because Section 62 will tell you that at least terminations based on proven incompetence of a worker, proven misconduct, maybe where there's also a redundancy, or and there's a legal restriction that has been imposed on an employee, prohibiting the worker from performing their work, then clearly those instances would be one that once an employer falls on, there's very little that anybody can do. It would amount to a fair termination, because if your employee goes out to commit a crime outside of work and he has to be placed in prison custody, clearly that person cannot come to the office and come and work. That would form a fair ground to terminate, or when we do a redundancy, or when there's proven misconduct. So you see that the law will tell you the proven misconduct. So the misconduct must be proven before you can say that I am terminating because of misconduct. And then where the worker over time has shown to be incompetent, so a number of appraisals have been done. So you don't just get up. Sometimes, one of the challenges we face, some of the termination letters, we write to inform you that your employment with this company has come to an end because you have shown not to be competent at your job, or you are not performing, or you are a poor performer. Then you ask the employer, how did you get this assertion that the person is not performing well? So, well, when we look at the way things are going, we think that they are not performing well. No, that's not a proper explanation, because to judge a person's performance, you should have conducted a number of appraisals to be sure that clearly it is not the entity's fault, or there are no issues on your side as an employer that is preventing the employee to deliver. So some of these nuances, I believe that once we are able to understand them and how we are supposed to lay them out, it makes it easy to treat terminations, because like I said, if for every 10 cases, 6 of them is bordering on termination, then it means that there's something wrong somewhere, that all of us, both the commission, the courts, employers, workers, all of us would have to give a careful look at it, and then let's see how we're able to find a fair balance that works for everybody involved.
Thank you, Steve. On the issue about proven misconduct, would you suggest that a disciplinary committee hearing into a matter and coming to a conclusion will suffice as having proved the misconduct?
Yes, I would recommend that at any time, so that we can be sure that we are definite on the direction that we are heading. So somebody misconducts himself either for failing to obey a lawful instruction or some other breach of the work rules. I'd suggest that we first of all try to find out why the person did that. But all of these things must be done in writing. I get it. There are a number of situations where the employer would come to the commission and say, oh, we put up a human face. Human face is good. I am an advocate for putting human face at all times, but it also should not be done at the detriment of others at the workplace, and also at the detriment of the employer's vision as well. So yes, at some point we have to put the human face aside and try to, crack the whip, for want of a better word. So yes, find out in writing why the person did this particular behavior or put up this particular behavior. If the reason given in writing is not satisfactory, put together a committee hear the person out so that you can tick all of the boxes when we come to, because we would want to know if natural justice was allowed or it was made to play. So that if based on just why did you do this? Oh, I am not sure I particularly did this, or I did this because of X, Y, and Z. And for you as an employer, you think that there are still questions to answer. Go through the process first. Don't just take the response alone and say that then based on this response, then let's go away. Unless in the response itself, the person says, yes, I did this, I am guilty of it. Then senior, like most of the time, it plays out in court. Then you are found guilty based on your own admission, not because somebody else that shouldn't show that yes, you have done it because you have said you have done it. So, but between the two of us, I'm not sure every employee would readily concede that yes, I did it. At all material times, there's some reason for saying I did not do it until facts are shown otherwise to show that clearly the person has done it. Then the decision can be made to let go. Then on that score, if that person decides that even in the face of all of this, I am either going to the courts or I am going to the Labor Commission. And the employer is able to show that this is the process we sent him through. We first asked him about it. We gave him a query letter. He responded. We went through the process. This is the report. This is the final decision. This is the letter ending the relationship. Then, unless there are issues with maybe how the committee was constituted or if it wasn't empaneled properly, then it could be a basis for somebody to challenge the decision. But if that is not the case, then everybody is safe and dry.
So that calls for the need for a staff handbook because most employment contracts will normally not have a disciplinary there, and even what the constitution of the disciplinary committee is will not be an employment contract. So you would agree that beyond the employment contract, business leaders or companies should invest in staff handbook or
Yes.
employment policy, so that because that will go beyond the employment contract to stipulate the disciplinary processes, because employers always get it right. They have a reason to terminate, but they always falter on the process, even though they may have a reason to. I don't know whether you agree with me.
I agree with you totally, because these things, like I say all the time, is to protect everybody within the relationship. And so you would find that it's only fair that employers put some good attention to their HR manuals or workplace policies. It's just to protect you as a person who has put together some good investment to achieve a certain outcome. Now, these things would help because, like you mentioned, the contract of employment would not be able to cater for all of these things, how a panel is supposed to be constituted. So the employment policy or the condition of service is one key area that employers must invest some good time in, and find people who are versed in the area, and they'll be able to run you through what will be an ideal workplace condition that you can use, and it will serve you good for a long number of years. Just that over time you must do a few reviews here or there, and if it's a unionized environment, then you know that you would have to get the union to ensure that you have a certain collective agreement in place that will cater for all of these things as well. How a person enters, how a person is kept within, how a person is promoted, how a person is disciplined, if there are issues, how to deal with it. Once these things are there on paper, when the issues come up, we just go back and go and find out what the paper says, and then we work with that, and that will help keep the employment relationship.
Okay, thank you, Stephen. Let's look at issues about redundancy, and
Okay.
you would often find that an employment relationship may be terminated on the grounds of redundancy. What processes should employers who have made a decision to retrench some employees go through?
Okay. Now, I am sure that before an employer says we're going to do some retrenchment, they may have done their own evaluation as to who would qualify to be retrenched, who would qualify to be kept within the establishment. Now, beyond the internal arrangement, an employer who contemplates to embark on such an exercise must provide a letter to the chief labor officer 3 months before the intended action. That, okay, so I think we're in the month of June. So if we are both employers and we want to do some retrenchment, what we must do is that we must inform the chief labor officer in writing 3 months ahead of our intended action. So June, July, August, we intend to let these people go. So that's what our letter will say, that in the month of August, we intend to let 10 people go. Now, these 10 people constitute, then we list their areas of work and the reason for which we are embarking on the said exercise. It might be because we're not doing well financially, or we are changing business direction, or we're even relocating, and as such, we cannot carry everybody along. So some of these instances would inform the decision of an employer to say we're doing a redundancy exercise. Now, beyond the 3 months notice to the chief labor officer, if the employment environment is one that has a union present, then the law is saying that let's have a discussion with the union to come up with measures that will mitigate the effect of the intended exercise. Once we've done this discussion with the union, if there is one, then we will go on to look at an arrangement where once we are doing a redundancy, means that people are going to be affected, people's jobs are going to be terminated. Then the law is saying that we have to.
So because some organizations may not have a union, we have to look at it from both sides. Where there's union, where there's no union.
Okay. So where there is no union, again, I would say that, and I would also advise that we engage the persons who are going to be affected as well. That, guys, we understand that times are hard. It's also hard for others. So it's just an open, honest discussion on how that we are going to treat the whole exercise of redundancy. And so if there is no union, it's only fair that the employees or the workers who are going to be affected are engaged in some discussion towards some measures to either limit the number of people who are going to be affected by the exercise, or look at other avenues we can explore to mitigate the effect of the terminations that will come up as a result of the redundancy exercise. So you would find that we will embark on a redundancy, but if, let's say, we are a group of companies and maybe one of the companies is not doing so well, we can make some workers of that particular entity redundant and still find some employment for them in other group or in the other groups if we have vacancies available. So these are some of the conversations that generally we can have. Now, beyond that, then we have to sit down to have a negotiation in the event where we don't have an already predetermined redundancy payout. So you would find that maybe in a condition of service or in a collective agreement, provision is made that in the event of a redundancy, let's say if you have worked under 5 years, you get 1 month salary or 2 weeks salary for every year you have worked. If you have done between 5 to 10 years, you get a month salary for every year you have worked. Depending on what our policy says, then we'll go and make reference to the various provisions in that policy and apply them. Now, where there are no express provisions, what the labor law is saying under section 65(4) is that let's sit down and do a negotiation. So the employer on one side, the workers who are going to be affected on the other side, if there is no union. If there is a union, then it means it's the employer and the union, because the union in that moment and at all times represent the interest of the workers. And so the employer will sit down with the union and negotiate where there is no clear provision on what is to be paid for redundancy. Because I've seen some collective agreements that are silent on what should be paid as redundancy. What you have there is that should redundancy occur, section 65(4) would be used. So we'll sit down and negotiate. That's what some people have. Whilst you'd have other instances where provision is made clear as to what is supposed to be paid out. So what the labor law does is to try to address both instances, so that if the provisions are already there, then there are no issues about it. But if the provisions are absent, then the labor law says the party should sit down and negotiate the severance pay or the redundancy pay. And then the labor law still goes ahead to say that in the event where there are still issues as to how we should go about the redundancy, the payment of the redundancy, then we should revert to the commission for intervention, and the commission, if the party should avail themselves, would intervene to guide them through the negotiation process to be able to come up with a clear payout for the redundancy pay.
As part of the process, is there a requirement to consider an alternative suitable work for those affected? Is there a requirement? There
is no strict requirement that you should find alternative arrangements for persons that are going to be made redundant. So it is, I am sure that, I don't know if the new review would have that kind of provision, because I know in other jurisdictions where before you say that you are embarking on a redundancy, you should find some alternate work for persons who are going to be affected before you can even commence at all. Otherwise, then it means that you are saddled with those persons. They will still be in your employment until you're able to find alternative work for them. Our current situation doesn't work that way. So our current situation is geared more like when the time is due and there is no alternative work arrangement for you, your best hope is that we pay your redundancy or severance on time. Beyond that, and even sometimes the payment sometimes delays, even though in the clear sense of things, it should be made at the last day of work. You find that there are certain instances where the payment will go beyond the expected payout period. But our operation, the way our labor law works now, doesn't have provision for strict compliance of alternative work arrangement before you can make somebody redundant.
Okay, you mentioned the fact that as a starting point, you need to give the chief labor officer a notice of the proposed redundancy 3 months before the start of it. So if an employer decides to curtail that process, does it mean that the employer must pay 3 months in lieu of notice for having curtailed that? Because I don't see any punitive measure for the employer, but I will construe that the employer because the 3 months will mean that the employee will be in work for 3 months and they'll still make a regular salary.
Yeah.
So if you're shortening the process, then it means that they have to get payment in lieu of notice for that. Is it a good thinking or is it a bad thinking?
It's actually not a bad thinking, because if you look at how the law has put it out, it says that notify the chief labor officer and the trade union if there is one to as well. Now, the whole idea of that 3-month period is to give you the chance to be able to conclude the negotiations if you don't have a written policy, and then you go ahead and pay. So where per the provision of the law, you're supposed to give the 3 months. If you don't give the 3 months, then it means that in its implication, if you're saying that the situation is so urgent that we have to let you go today, and then we sit down and discuss the other issues tomorrow, then it means that that wait period should also be a factor that should be part of whatever is agreed on to pay. So yes, it's fair for anybody to say that once you're truncating that period to the chief labor officer and to the people who are going to be affected, then it means that you would have to look at that period as well and do pay accordingly, so that you ideally satisfy the whole period of that the 3-month period, and not that you can truncate it and just quickly sidestep the process and run away. Otherwise, you would find people just write to the chief labor officer today, and then tomorrow they are telling people that you have made redundant, go home, and they will lose out on that space where, because if you're made redundant, it's not just the fact that you're losing your job. It comes with other implications as well. There's the psychological part, there's the social part. So that period, in the intention of the lawmaker, is to give you time to begin to adjust and tell yourself, okay, beyond this time, I'll no more hold myself an employee of WTS. And so what am I going to do next? How am I going to adjust? So you begin your adjustment within that period. Now, if the adjustment period is going to be truncated, then it is only fair and proper that it is duly rewarded in the same sense.
So what would you consider to be a fair reward? Is it the actual salary of that person for the 3 months, or you think that some money should be added to the payout?
Well, it depends on how the parties would want to treat it. But if you ask me, I would say that salary for that same period is a fair arrangement for everybody involved. And then if the parties also want to defer that approach and go look at a certain percentage to say, okay, this percentage ideally on top of the redundancy pay should cut across for the sidestepping of that particular the 3-month period, then it's what the parties have decided to do. But for me, I would say that 3 months is a fair reward for truncating the period.
I'm more inclined to agree with you that yes, it should be the actual salary of the person. My other question relates to the payout. There is no statutory basis for determining how much should be paid out as redundancy. Largely depends on industry practice. Some industry will give you 2/3 of per year of service. Some industries will give you 3/3 of the number of years that you worked. Does the Labour Commission has a position on how the payout should be, or you would only have regards to the strength of the employment of the employer's financial resources?
Well, the commission as of today doesn't have a clear standout as to what would qualify as a minimum payout for severance or for redundancy. So largely attention is given to the circumstance, the strength of the employer, the ability of the affected worker to immediately find work or not. So these are some of the elements that the commission would look at. But generally, there are no clear-cut payout regime. So you look at what the industry pays, and usually where there are instances of a dispute, the orders are directed in terms of what the industry practice is. So you would find out what happens within the financial and banking sector might be different from what happens in the mining sector and in the construction sector and in the various other sectors as well, like food and beverages. So depending on where you find yourself, we can look at what the industry practice is and give orders or directives accordingly. But unfortunately, our law and then the commission, which is supposed to be the person who has absolute control over how the law is used in terms of managing the employment relationship, is yet to have a certain standard that parties in the event where they don't have a clearly put out redundancy payout can fall back on. I know in other jurisdictions, the laws are pretty straightforward, that if you work between 1 year and 5 years or 1 year and 3 years, you get maybe a month. I know in other places where if you work for under 2 years, you don't even get to be paid redundancy should a redundancy take place. I think one of these European countries has that work provision in their labor laws.
The UK has it.
The UK has it. Thank you. So for them under 2 years, when we are talking redundancy, you don't even worry yourself. Don't come because you are not covered. And then beyond 2 years, provision is made for you. So that is what their law has done for their jurisdiction. I am hoping, because sometimes the reason why people would come to the commission is simply because they are failing to agree on whether 1 month for every year work should be okay, 2 months for every year work should be okay, 3 months should be okay, or even 1 week for every year work should be okay. Now, these instances, I believe, can be resolved simply by having a review of the provisions under Section 65, which would make provision for where it is silent and, have a certain staggered approach towards payment of redundancy, so that we look at the number of years you have worked, and then we can pin it and pay a number of weeks or a number of months for those particular periods. That would go a long way to help everybody involved in the employment relationship.
All right, thank you, Steve. We have a number of questions in the chat box, so I'm going to go through those questions.
Okay.
Then I'll come back if we have not exhausted all of them. So there's a question about what is the process for filing complaints? File a complaint at the workplace on the basis of discrimination and harassment. Is there any processes at your end to file a complaint about discrimination and harassment? And there's also a question about, can report or violation of law be anonymous, where the person has not disclosed it? And
Okay.
how long does it typically take for the commission to do an investigation when a matter is reported? And the fourth question relates to whether an employer can decide to say, I am putting only one person redundant.
Okay.
Just a
So
person.
okay, let me start from the last question, and then we'll work our way back. Now, the decision to make a person redundant is a sole preserve of an employer. So the employer can decide based on the necessity of work. So if you look at section 65, if the employer contemplates any major change in terms of operation or program or policy, then you would say that as for the number of persons, unfortunately, the law is quiet on which basic minimum would qualify as persons that an employer can make redundant. And so it's for the employer to decide largely who he would want to keep and who he would want to make redundant. And so I would say, to answer that question, I would say that there is no bare minimum made provided under the labor law or even with the operation of the National Labor Commission as to whether you can make just a person redundant or two persons or three persons. If the employer thinks that with the new nature of business, one person should be made redundant, the law would not question the idea behind making that one person redundant. What the law will question is whether or not the person has been duly catered for in terms of receiving your redundancy pay. Now, in the ideal situation where somebody lodges a complaint with the commission, now within 72 hours or within 3 days, the commission is supposed to serve a copy of the complaint on the other party for a response, so that the commission will be apprised with the facts of both parties involved in the dispute. Now, the first letter to the other party, let's say if I'm an employee and I lodge a complaint with the commission for the most popular one, unfair termination. Once I lodge a complaint today, then within 3 days, then the commission is expected to serve my employer a copy of my complaint for their response. Now, this letter to the employer is giving 14 working days to respond. If within the 14 working days or after the 14 working days, no response is given, then there's a 7 working days notice reminder to the said employer. And then if that is also not met, then there's a final reminder to the employer. And once these 3 instances are crossed, the commission can proceed to hear just the employee alone and then go ahead to give a decision on the complaint. Now, some of the new innovations that have come up now is that these days what we do is that when we hear just one side because the other side has not responded in writing or even turned up for any of the invitations to appear before the commission, once we hear the other side, we make the proceedings available to the other party as well, that, well, you have not showed up. However, we have gone ahead to hear the matter. This is what the person is saying. We're giving you 7 working days, depending on the situation, to respond to not just the complaint, but also the proceedings that has already transpired. Now, if within that time we don't get to hear from you, then we on our side can say that we have done our bits, and so we can go ahead, give a decision on the matter, and that decision ideally would qualify as one that you can find from any of the high courts in Ghana. And then there was the question of whether or not. So in terms of duration, let me just add that if the disputing parties are compliant, it shouldn't take give or take more than a month for a person to be given a hearing date if the persons are compliant. So I lodge a complaint today. Today is Wednesday. Ideally, by Monday, my employer should be served. If the employer is compliant and they serve the response within the 14 working days, you realize that within a month, you should receive a letter inviting you to appear before the commission for settlement. Then, depending on how the discussions will go when you appear for settlement, you can be certain that in the ideal situation, like I've already said, under 1 month, you should get a date to appear for a hearing. Then there was a question on whether one can make an anonymous complaint before the commission. Yes, there are a number of instances where people have walked in and said, I want to make a complaint, or people have even written in to say, well, we work with company X, and these are the challenges that we are facing, and we need the intervention of the commission. The commission would deploy officers to ascertain the facts as it has received as to whether or not they are true or false, so that the commission can be in a position to now invite the management to appear before it. And then we bring these issues up, we discuss them, and then we're able to find some solution for the workers who are affected. So yes, anonymous complaints are also received by the commission. Senior.
Thank you very much, Steve. There's a question about, can you explain what constitutes a force majeure? As a follow-up, does COVID-19 fit within this this definition? Does an employment contract become suspended in the event of a force majeure?
Well,
There's also a question about the maternity leave, the minimum being 12 weeks. The question is there a maximum period? And there's a question about an employer decided to pay an employee performance bonus during maternity leave, but only pay the basic salary of the employee. Let's take this one up.
Okay. Okay, so on the performance bonus, now the nursing mother would only qualify for the payment of performance bonus if it covers the period within which she was still at work prior to delivery, because performance bonuses are tied to your work output. So if for 3 months you're on maternity leave, so you cannot go to work, if at the end of the year we're looking at your performance over the period, then ideally your performance bonus would be reflective of your, let's say, your 9-month period of work. So the employer cannot say, because you have gone on maternity leave, you do not qualify for the payment of performance bonus at all, unless your performance is one that does not qualify you to be paid the bonus. But if within a given calendar period, you have carried out work prior to going on maternity leave, if we're making payment for performance bonuses, it should be reflective of the period that you had performed work before going on maternity leave. Now, if you're on maternity leave, automatically you are not doing any work, you are not performing. And so for that period of maternity leave, it will be difficult for an employee to make a claim on the employer that because I am on maternity leave, pay me performance bonus. No, because you're on maternity leave. The idea is to give you time to bond with your newborn. So do that. But any work you may have done prior to, then by the operation of how these things work, clearly you qualify to be paid the performance bonus. Now, the law makes provision for a minimum period, but it doesn't make provision for a maximum period. So you'd find that, like I said, there's a 12 weeks for minimum for every woman worker. However, if the employer wants to build on this 12 weeks period, the law will not frown on it. So I know there are companies in Ghana here who give us as much as 16 weeks as maternity leave. for their female workers. So the minimum is for everybody. It's on your employer to decide if he wants to work with the minimum or he wants to build on that minimum and pay you or give you more periods as maternity leave beyond what the minimum requirement is. Then there's the question on force majeure. Yes, clearly with the nature of what a force majeure is, it's enough to frustrate any contract so that if the instances are such that, but for that particular activity or that occurrence, the employment relationship would still have persisted, then you would say that once it occasions itself or once it comes up, then we are good to say that, well, because these things have come up, then clearly the relationship has to come to an end. So let's say we run an enterprise and there's a flood and the whole place is flooded so much that for the next year or two, it will be difficult for the business to still be in existence. Then that is enough to say that force majeure has occurred and therefore the contract ideally has been frustrated. So you cannot give any consideration. There are no obligation on any of the parties to each other because of the occurrence of that event. And ideally, nobody at the time COVID came, I am not sure that even the experts at the time knew it could be this extensive that it would even affect our daily lives and even how we and change the nature of work. So COVID, yes, you can consider COVID as an instance of a force majeure, and that's one instance where an employer can rely on to then safely bring the employment relationship to an end. Senior.
Yeah, thank you, Stephen. On the issue about the bonus, most companies would have bonus as being discretionary. It might be based on a number of factors.
Sure.
So what is discretion is quite something that may be affected.
Mm.
So how would you be able to assess? Because I mean, somebody might go on maternity leave, but based on a number of criteria or performance improvement program, the person may not be eligible. I mean, how would you be able to assess that when the company says award of bonus is discretionary?
Well, it is for these particular reasons why, like we said earlier, it is only fair that we make sure that we have employment manuals in place, because the employment manual would clearly explain the conditions that must be met to qualify one to be paid performance bonus. I am not an advocate for discretionary payment of bonuses or I feel that the work environment and its policies should be definite on what you must do to get what, so that it takes away that notion of, if my manager doesn't like me, then on discretion, my manager can say that, well, the last time you were not able to produce this particular letter when I asked for it in 20 minutes, and so you do not qualify to be paid performance bonus. So for me, a clear standard on what would qualify one to be paid bonus is more beneficial to the relationship than leaving it to just discretion, because discretion can be relative. What is okay for me and you might not be the same for another person. And so when we place these things under discretionary, so I've seen a number of documents that say that yearly bonus would be based on the discretion of management. So it means that we can all put in our best, but if at the end of the year, management says that, well, we can exercise discretion and we think that we've not done enough to pay annual bonus or performance bonus, then it means that year nobody gets anything. But if we are clear on the various timelines and the goals that must be achieved within those timelines, we do away with discretion. Automatically, it would also do away with anybody coming up with the situation of, I think that I deserve to be paid or not deserve to be paid. But even if we have a discretionary arrangement that has certain basic elements that must be satisfied before it is a person is awarded that bonus, then that is also fair, and that is also clean for everybody within the relationship, so that it's not just based on my manager's discretion alone, but I should also on my part be seen to have achieved X, Y, or Z within this particular time to qualify to be paid the performance bonus, whether I go on maternity leave or not.
Okay. I think it's quite an arguable fact, because performance is relative and is subject to a number of factors. And so, in my experience, I know employers will normally have some certain criteria for assessing the performance of a person. And that's the reason why discretionary is there. And sometimes a person may leave partway in the course of the year, and they may not want to exercise the right to give the person a bonus or whatever entitlement the person is due. So there are a number of things that goes into it, but those traditionally, those discretion will be exercised in a fair manner, a fair process. Yes, but they will normally make it discretionary so that when those events crystallize, they be able to exercise that power. But that's for another forum. I mean, someone's asking about whether paternity leave is provided in Ghana, and if it's not stated within employment contract, can an employee take some off for continuous professional development? Does that time off come out of the employee's leave? And is the compulsory pay compensation of 3 months salary when an employee's employment is disruptively terminated? Is that okay? Are you good to take those three questions?
Yes, I am. Okay, so if you look at how our law work, with the last question, there is no clear provision as to the payout should you terminate somebody. So somebody was asking if it's compulsory that an employer pays 3 months salary to an employee when they terminate their employment. Our labor law doesn't say that when you terminate somebody, pay the person 3 months salary for terminating the person. Now, I don't know if the person is asking this based on the notice clause within the contract of employment or not. But if it is in compliance with their notice clause in the contract of employment, then yes, it is in the contract of employment that if we have to terminate you, we have to give you a notice of 3 months or 3 months salary in lieu of that notice. If that is what is in there, then once the employer pays it, then there's nothing wrong with it. And actually the employer is supposed to pay it. Now, if that is not the provision in the contract of employment, then like I said, our labor law doesn't set out a payment schedule that if you terminate somebody's employment abruptly, you should pay the person 3 months salary for the said termination. No, our labor law doesn't say that. If the person takes up the issue with the courts or with the National Labor Commission, then if it is found that your action amounts to an unfair one, then some compensation can be awarded in that respect. But it's also based on the facts of the matter, and then the courts or the commission would now put a compensation in terms of an amount on the facts that is presented to it. And then the second one related to, Senior, if you can remind me of the second and the first.
Paternity leave, was about paternity leave, and whether it can come out of your annual leave. Is there provision in the labor law about paternity leave?
So our labor law is silent on paternity leave. So if within the establishment or the organization says as for our ladies, the law already makes the minimum provision but for the gentlemen, if your spouse should deliver, we'll give you 5 days or 10 days as paternity leave. That's an enterprise-based arrangement, and there's nothing wrong with that. But if the enterprise doesn't have that, then maybe what you can do is that you can maybe make an application for a compassionate leave and then cite the fact that, you know, your wife has delivered and you want some bonding period with them. It's up to your employer to grant it or not grant it. The employer is not under compulsion to grant it because it's compassionate. They decide if they will grant it or not. However, if it is such that you need the time, then if you want to go, then you take your annual leave, a part of your annual leave. So it will not necessarily be described as a paternity leave, even though the idea is to be there for your wife and your newborn. But where the employer doesn't have that provision, then maybe in your mind it will qualify as a paternity leave, but on record it will be taken from your annual leave, and that is fair. There's nothing wrong with it if a man's time to bond with his newborn is taken away from his annual leave.
Okay, let me read further questions. So, if an employee has a fixed term contract for, say, 2 years, can either terminate given a month's notice? An employer can terminate such clause. Can this be considered as a fair termination? And can employee claim his salary until the end of the contract? What happens if the employer does not write to chief labor officer and yet goes ahead to lay off workers? And the third question relates to that. Redundancy applies to fixed-term employees employees on fixed-term contract.
Okay. All right. So you would find that for the person, the question on the fixed-term contract, I think that we would have to give careful attention to what the termination clauses in the fixed-term contract say, so that if the clauses are such that the employer can terminate the contract within the time period, the fixed term period, then that is what would suffice. However, if there are issues bordering on how the contract was terminated, and one party to the contract feels that it wasn't terminated properly, then that party only has recourse to either the courts or the National Labor Commission. And then depending on what you are seeking in terms of reliefs, then it may either be granted or otherwise, because where the contract doesn't say that if we terminate, you are qualified for the unearned period, in terms of we'll pay you salary for the period that will be following the termination. Then if you want to make a course, if you want to take a course of action, then maybe that is what you would want to go and plead for. But it is also, again, up to the authority that will be presiding over the matter to now decide as to whether or not it should grant you salaries for the remaining part of the contract, or give you salaries for a portion of the remaining part, or not give you anything at all. The facts would now determine how that particular instance would be treated. Now, if you look at Section 65, it doesn't make provision for punishment. Let's describe it as such, for persons who do not write to the chief labor officer. Now, like I said, once you sidestep any process within this our law, when there are issues, your protections are limited, because like even with our roads, if you decide to overtake on the wrong side of the road and an accident happens, I'm not sure that the motor court would want to know your reason for overtaking on the right side of on the wrong side of the road, when you know you are not supposed to do an overtaking there anyway. So yes, like I said, then it means that your protections are limited. The law is saying write to the chief labor officer 3 months before your intended action. Write to the chief labor officer 3 months before your intended action. You're safe. Failing to do that would mean that if there are instances down the road, like I've already mentioned, your protections are limited, in as much as you won't find the law clearly stipulates that a failure to do so would lead to X, Y, or Z. In the event of a dispute, I know that these are some of the things that are considered in making a decision on how to treat the payment of the redundancy pay. So it is a caution for all of us that yes, you might think that sidestepping the process now is okay, but when an issue comes up, you should also have it at the back of your mind that your sidestepping of that process would also influence the thinking of the person or persons who would be adjudicating on the matter. And then one person was also asking if the issue of if contract workers also form part of persons who can be made redundant. I think that section 66 creates a certain exception as to the whole part of the protection of employment, where you find that workers engage under a contract of employment for a specified period of time or for a specified work, or workers who are serving probation and workers who are engaged on a casual basis. These persons may not necessarily have protections when it comes to issues on that whole part of the law. And so this whole part of the law includes that of redundancies as well. And so for a fixed term contract person, it will be difficult for you to take a course of action bordering on redundancy, because your time of start of your work and when your work is supposed to come to an end has already been predetermined. I want to believe this is what informed the framers of the law to place fixed term workers under those who are exempted ideally, or who are considered as exceptions to the provisions that apply on that particular part of the Labor Act.
Okay. There's a question about whether the Labour Commission has labour inspectors.
That's the Labor Department. So the Labor Department has officers who are workplace inspectors who are supposed to come around to ensure that the general conditions of work are in order, who are supposed to find out the needed materials to carry out work, either to protect the employee and the employer are in place. So it's the work of the Labor Department to ensure that these things are done. So they have labor inspectors. The Labor Commission does not have labor inspectors. What the Labor Commission does is that it can investigate issues bordering on any workplace activity. Now, once we do that and we think that there are certain infractions in the general conditions of work, if it borders on the jurisdiction of the Labor Department, their attention is called and then they take over that particular issue and get it resolved. And once they are done, they give a report to the commission. But if it is one that falls within the absolute jurisdiction of the Labor Commission, then the commission would not defer to any other body, but it will take charge of the situation itself. If it has to deploy officers, it will deploy officers to meet with a section of the workers, a section of management, to be able to iron out whatever issues it has uncovered, to be able to make sure that everybody is protected at work.
We have further questions. Someone is asking about what are the employer's obligations regarding legal obligation regarding reasonable adjustments for employees. Reasonable adjustments.
In terms of what exactly, if the person can make it a little clear, it makes it easy to answer his question, because reasonable adjustment could be for a number of reasons or for some particular reason. So maybe you are in school. So yes, then you want some time off your work schedule to be able to attend class. Let's say you do an evening class during the week. Those are instances that will qualify for reasonable adjustment. Or maybe for a particular reason, maybe where you stay, the distance to work. So maybe you can have a reasonable adjustment as to, okay, you come in Monday to Wednesday, but Thursday, Friday, work from home. So these instances, for me, would qualify as reasonable adjustment. But reasonable adjustments are always tied to a certain event or a certain activity. They are not made in a vacuum. There should be an instance or a reason for which an employer may want to make some adjustments to the schedule of work of his or her employees.
Okay. Let's go on to other questions. Is it right for an employer to dismiss a staff after the staff has submitted his or resignation letter? Can the former employee take up at the commission? There's another question about if there's a dispute between an employer and employee, can the employee go to court straight away for redress, or they must start with the Labour Commission?
Okay, so both the High Courts and then the Labour Commission both share jurisdiction on issues bordering on unfair labor practice. And so a person can elect to either go to the court or to the Labour Commission to have their issue heard. So it's based more on a person's decision as to which forum he would want to adopt to address whatever challenge that he has. Now, then there's also the question on, Tina, what was the other one? The first one.
The first one was when the person has resigned, but the employer decides to still terminate him or her.
Okay, so I fail to see why, as an employer, once my employee has written to me that I have resigned, I would want to say that I am rather terminating your appointment. The person has written to resign. Now, if for any reason, or if there are reasons underpinning the resignation, then maybe we would have to look at it. So let's say, as an employee, I am a subject of an investigation at the workplace, or I am a subject of a disciplinary committee hearing. Then even before the disciplinary committee brings me in, I say that I am resigning from work. I have chosen to exercise my right to leave the enterprise. What that would mean is that I am required to serve the appropriate notice before I leave. Now, if the appropriate notice is not served, it might be an instance where the employer would say, no, we cannot accept your resignation, and you show reason why. So, because you are expected to give this number of reasons or this particular number, this particular period of notice before your resignation can be effective. Now, once the person brings in the letter to say, I resign, let's say effective today, any action done following that is, I don't think that we should even have any activity following it once the person brings in a letter anyway. Because like I said, unless there are instances, or the instances I cited earlier, that a person is a subject of an investigation at work, either to do with some misconduct or some financial malfeasance, or taking away of a certain company property for which the company is looking into, then on that basis, an employer can then say, no, let's run through this process before we can look at your resignation. But then again, once the person goes, if the person is not a subject of any form of investigation, I don't see why an employer should write following an employee's resignation that, no, we are rather terminating your employment. It's neither here nor there. I think it's more of an afterthought than any other thing. So if they bring the letter, let's accept it in good faith and let them go. Unless, like I've mentioned earlier, unless there are persons under which we are doing some investigations, then we may want to have the investigations completed before we can accept the resignation.
Okay, all right, thank you. So that depends on the question of fact on that point, right? All right. So is it lawful for an employer to insist that an employee gives notice of more than 1 month for unemployment for a period of 3 years? That Straj has a mandate to look into labor issues on behalf of an aggrieved employees.
Okay, so the law sets a minimum of 1 month notice if the relationship is above 3 years. So that is what the law says. However, if the parties in their employment contract say that if we have to terminate, on my side as an employer, I will give you 2 months notice or 2 months salary in lieu of the notice, and the same applies to you as the employee, then that would be it. So if me as an employee, I have to leave, then I am supposed to give them 2 months notice or 2 months of my salary in place of the notice. Now, if that is not the case, then the employer cannot force an employee to serve notice beyond 1 month or pay beyond a month's salary to cater for notice when the employment contract has not said so. If the employment contract is silent, the best provision for the parties involved is the provisions within the labor law. And that provision is saying that you either give 1 month notice or you pay 1 month salary in lieu of the notice if the relationship is above 3 years. Now, the other question relates to whether or not SRAJ can adjudicate on labor matters. Well, I know SRAJ's jurisdiction relates to human rights abuses, but if it comes to labor or employment relationship disputes, your best forum is the National Labor Commission, because it is the body that is established under the Labor Act to adjudicate issues bordering on the employment relationship. So I know instances where SRAJ has received complaints bordering on labor, and they have referred same to the commission to say, please look at this and help the parties to resolve the matter. There are also instances where SRAJ has attempted to resolve the issue, but at some point have hit a certain obstacle because one of the parties has come up to say, well, even this whole issue, we are not even supposed to come before you in the first place. So going forward, we will not come because we don't think that you have the authority to preside over labor-related matters. So yes, if the whole dispute is, if there's an element of human rights abuse, SRAJ can look at the human rights abuse portion and then advise the parties to avail themselves to the commission for the labor-related portion to be dealt with. But it would be improper on the part of SRAJ to go ahead to try to adjudicate on the labor-related issue when ideally it does not have the mandate to do so. Once they do, a party can go to court and quash that decision that SRAJ will make, and that would, I know it will stand in court if somebody should do that.
But Steve, what is the power of the Labour Commission in terms of enforcement of an award which has been reached at your level? Should they go to the High Court to enforce any agreement reached by you, or you have coercive powers?
Well, unfortunately, the commission doesn't have coercive powers. And so if there's any breach of an agreement or a decision made on our level, what we do is that we go to the High Court for enforcement of that particular decision. And it's something we do on a regular. So there are decisions or directives or orders issued by the commission, a party fails to comply. What we do is that we go to the court to go and enforce the decision of the commission. And like I said, we do that on the regular.
Would the complainant would have to pay for such, or is free?
No, the enforcement is done at the instance of the commission, and so the beneficiary of that particular order would not have to pay anything. But sometimes too, we are constrained financially. So sometimes the parties themselves will say that, well, because of your financial constraints, I would probably want to cater for making the application to the courts so that you can go and represent my interest, because after all, the enforcement is to serve my interest. But if at the present, the commission is not in the position to go and make the necessary payment to have the enforcement done in court, then you have the parties themselves opting to make that payment just to speed up the process of getting their decision enforced.
All right, thank you. Last question from the chat box is if you could touch on employment of foreigners and whether there are any special requirements.
Well, for foreigners, usually the entities that will be bringing them in, they reach a certain service level agreement with them before they bring them into Ghana. So you would find that I have seen a number of instances where the employment letter says that in the event of any dispute, they will use the country of origin of the said employee to resolve the dispute. So in that particular case, if an issue should come up, then it means that all of the institutions in Ghana, everybody's hands is tied on how to adjudicate the matter, because the parties have decided that if there are issues, they will use the country of origin of the said expatriate to resolve the matter. However, where the contract of employment doesn't say so, then it means that that particular expatriate is subject to the laws of Ghana from our 1992 constitution to the very small law, inclusive of the labor law as well. So that if there are issues bordering on the employment relationship between an expatriate or a foreign worker and his local management, then the parties can resort to the authority or jurisdiction of the Labor Commission to seek redress. And the Commission on a daily deals with issues that borders on disputes that one party is a foreigner. Just last week, I handled an issue involving 2 South Africans, 1 Lebanese and 1 Portuguese. They had an issue with their employer here in Ghana. They actually reside in Ghana, but they are not Ghanaians. And so they had an issue with their employer. They came to the regional office here in Tema. And we are literally done with resolving the matter. We just need to put together an agreement for the parties to come and sign tomorrow to just seal the issue. So yes, if once the employment contract is silent on which law would be used to resolve the issue, why not? Then it means that our labor law, whoever it is covered by our labor law, because if for nothing at all, you are working within the jurisdiction of Ghana.
It was not the issue about the governing law, but whether there are some registration of those contracts with maybe chief labor officer, or whether I think from that angle, not
okay.
From
well,
that angle.
From that angle, no. Usually they bring them in, they come and work. I think that the things you have to satisfy is work permit from the Ghana Immigration Service, so that the person who is coming in as a foreigner, and yes, as a foreigner, be they Ghanaian or not, that person must have a work permit to be able to work in Ghana. The absence of a work permit would mean that if issues should come up, the Ghana Immigration Service and the particular employer would have, and the employer would be made to answer a few questions as to why you bring in a foreigner without giving the person or making an application for a work permit. So if you want to bring in a foreigner to come and work in Ghana, you must secure a work permit for the said person. And usually the work permit, sometimes they let the persons themselves make an application for the work permit, and then it is granted for them, or the employer will make the application for the work permit on behalf of their foreign worker, so that once the immigration service grants same to them, then the party can come in and then officially carry out work in Ghana without any issue. So the work permit is an essential documentation that an employer should seek for his employee if that person is a foreigner, or request of that particular employee to have before they can employ them in Ghana. I think that's what on that score, that's what I know applies. You should have a work permit.
A lot of questions are coming. We may have to bring you back on another session because we get a number of requests. But would you want to touch briefly on the minimum wage for us?
Okay.
and the living wage?
Okay. So the living wage ideally is you can consider it to be what people ideally earn to be able to cover their daily expenses, and also to live life comfortably. Let me just describe it that way, so that there are payments that are made by employers to help their employees to meet the daily requirements of life. The minimum wage, on the other hand, is what government, looking at the nature of the economy, sets across as the minimum pay or the minimum wage that every worker within its jurisdiction is supposed to earn for every particular day. So ideally, your minimum wage is what government has said that if you are in employment, if you don't get at all on a daily basis, you should be rewarded or you should be paid a particular amount. So I think I mentioned earlier that the current minimum wage is 14 cedis 88 pesos. Ghana, in Ghana, we don't do living wage. What we do is the minimum wage. And I think that there's been a number of calls now to have a conversation in respect of having a minimum wage designed to reflect a living wage rather, because living wage seeks to inure to the benefit of employees way better than the minimum wage, because the living wage considers factors such as food, such as water, housing, transportation to work and back, healthcare, education, clothing, and also has provision for unexpected events. So that's the idea behind the operation of a living wage. But you find that as for minimum wage, government says on negotiation, everybody should be paid 14 cedis 88 pesos. As to whether that is adequate or not, if we look at the elements of what constitutes a living wage, we can all be satisfied that that particular 14 cedis 88 pesos is woefully inadequate, because it doesn't have room for these elements. It also doesn't take cognizance of a person's marital status, the number of children they have, the position they have at work, transportation to work and back, housing, issues like that. So between the living wage and the minimum wage, I will be an advocate for a living wage, because if for nothing at all, it will also inure to my benefit as well. But how they both work, living wage works better for the interest of employees than the minimum wage.
All right, thank you. So would we see a day where, daily, those who work on an hourly basis are given a specific hourly rate? Or because at the moment we have rate for a day, not rate per hour, and that in itself undermines economic growth of those persons. Do we see a future like that?
Well, I am praying for a future like that, at some point that policy decision can be made. I know that there's been a number of calls to have even our minimum wage not to reflect for a day, but to be reflective of on an hourly basis, so that if every worker is having a minimum wage of, as we have now, 14 cedis 88 pesos for every hour of work, automatically what it would mean is that, unless my mathematics is that bad, it would mean that on the average, every worker in Ghana, irrespective of your qualification, the minimum salaries any worker, and I mean in this instance, any worker, should be carrying home, should be within the region of 2,000 cedis and above, unless my maths is that bad. But you would find that because we've pegged it on the whole a complete day, if you do the calculation, it's very little. The quantum is small. But if we should convert it to reflect hourly basis, I am sure that everybody would get some fine comfort to be able to afford the daily essentials of life. But it will take a while. I know a number of persons who are pushing for this, but they are not getting, number one, the needed support from society. Number two, they are not getting the needed support from the political powers that be. So it's made that call very silent. But I know there are those calls that keep going to the corridors of power, that let's have our minimum wage reflect on an hourly basis rather than on a daily basis. But we will get there. At some point, I know we will get there.
Yes, indeed, we are going to get there one day. Just a matter of time. Yes, thank you so much, Stephen, for coming. It's been quite an insightful presentation. You answered the questions very well. Just to do a recap, you talked about the fact that the Labor Act applies to all workers, and you talked about the security sector. What I do, the security services, it excludes the security services. You talked about the fact that employers must make sure that they secure the employment relationship with the employees with a written contract. And you went about to talk about what must go into it. So the name of the employer, the job description must be clearly mapped out. You talked about sick leave, annual leave. You talked about notice period, circumstances under which the employment relationship will be terminated, and other provisions. So you talked about that. You also talked about the fact that there are certain instances where the employment relationship may be terminated, and that is based on the employment contract and what has been provided there. But they must be done in a way that it will be fair process. And you talked about the fact that the court in Ghana says that you are not supposed to give reasons for terminating, even though we have our own issues about that that requirement, that position of the law. Then you went through redundancy. You talked about the process that it is required that the employer would notify the chief labor officer. But even before that, there must be economic or technological reasons or operational reasons that give rise to the redundancy. Once that decision has been made to retrench employees, then you have to notify the chief labor officer 3 months before the start of it. You talked about the fact there is no statutory payout for redundancy. And so this is a question about negotiation. So where there are unionized workers, you have to consult them. Where there are no unionized workers, it's good to consult selected employees or the employees themselves to go through the process. And you talked about, you answered other questions. We've had an extensive day, and I cannot repeat all that we'll discuss here. But the key takeaway is that if you are in doubt, I'm sure they can give a call to the Labour Commission. And one of the ways that you can also manage your risks, if you're not sure, call your lawyer. I mean, I'm right. I'm just a stone throw here. If you have a problem, you can just give us a call. There are many lawyers in the country. So if you have any labor matter, you can consult your lawyers or you can consult the Labour Commission. I'm sure it's a very friendly environment, and so they're always open to answer your questions. And I've seen that they're very proactive. Emails, they'll respond to you. Stephen is always there to support you. So on behalf of the UK Ghana Chamber of Commerce, I would like to thank Stephen for making time for joining us, and Achoba, Sarah Adelaide, Jocelyn, Immaculate, thank you very much. And at the right time, we'll come back to you, Stephen, for another session.
Sure.
Okay.
Sure.
So thanks everyone for joining, and have a nice day.